Welcome. This is the McDermott seminar on GDPR for academic medical centers and life sciences companies. An implausibly long title for our seminar. I am Ashley Winton, and I am delighted to be joined by Bernadette Broccolo and Daniel Gottlieb, who will introduce in a second. First of all, thank you for joining us on this our webinar. We have, and I will warn you in advance, we have too much material to cover in this webinar, so please do not be alarmed if we don't cover every point. These slides will be available to you afterwards, and of course, we'll make ourselves available to answer any questions that you have after the webinar. This is a series of webinars, and I'm pleased to announce that the next one, GDPR at the 11th hour, is on March 21st. So I'm looking forward to that as well. Please do join us for that. And lastly, I'm told that I have a secret CLA code, which will be mentioned to you later on in the seminar for those of you that collect CLE points. And so please look out for that towards the end of our webinar today. So there we go with the admin over. I wonder if Bernadette and Daniel, whether we should introduce ourselves quickly. And Bernadette, perhaps start with you.
Thank you, Ashley. I'm Bernadette Broccolo. I'm a partner in the health advisory practice at McDermott in the Chicago office. And I have been practicing in the IT and privacy area for more decades than I would like to admit.
And this is Daniel Gottlieb. I'm also a partner in the health practice in Chicago of McDermott, Law & Emery. And my practice likewise focuses on data protection matters, health information technology contracting, and government program reimbursement, fraud, and abuse matters related to technology use and data reporting. Here, Ashley, turn it back over to you.
That's great, and you know, as you can tell from my crazy accent, I am based in London, where my practice is privacy in the health and healthcare. So here we go. Look, now this is the agenda we've got today. So I am going to give us all a quick overview of the GDPR, and I'm sure you've read about this in many places. So I will do this in a very straightforward and direct fashion, and then Daniel's going to look after us, looking at some really interesting puzzles for U.S. healthcare providers. Bernadette will look at some really interesting example and use cases for us all. And then actually, why don't we take your questions at that point? And if you have any time left over, I'll speak for a few more minutes, if I may, about some particular supply chain risks, which I don't think have been properly identified in the things that I read or see in relation to the GDPR. So there we go. That's our plan. So let me start then by quickly talking about the headlines. Now, I actually think there's probably only 3 or 4 things you need to know. The first is there's an expanded scope. You'll all be familiar that in Europe, our definition of personal data is much broader than PII. And the definition in the GDPR looks remarkably similar to the current definition of the Data Protection Directive. However, there's some subtle and important differences. And actually, not least because of Brexit and the calming force of the ICO being withdrawn from the table that's in the center of Europe where policy is decided in relation to data protection and privacy, I think we'll see even more rigorous interpretation of the definition of personal data, which means it will have an ever more expansive scope. It will include, without doubt, data which alone is not personal data, but which could be made personal data by reference to second data sets which might not even be in your possession at the moment. And it will also include genetic data and data where you can single out individuals. So much broader. It also has expanded scope in relation to territorial application. It now has an extraterritorial reach, and Bernadette in particular will look at that, and it's a very interesting application of the law. The GDPR clearly affects how you engage with individuals. And you're going to most see that in relation to notices, consents, and these additional rights that you need to give individuals. And I'm sure people have heard about the right to be forgotten, the right of data portability. All these things now require a process in place to allow you to meet them. And then it will change the way that you operate your business. And so there's this new emphasis on accountability and governance, and new emphasis on the changes to your contractual arrangements. And some of the really important aspects sit actually in these provisions. And then lastly, bits everyone have heard about, new requirements on data breach and security. Remember, security is defined extremely broadly. It's not just hacking. And the fines, everyone talks about these either 2% or 4% of worldwide turnover fines. Actually, I really think the real risk sits in litigation and these quasi-class actions that could be introduced under the GDPR. And if we have time, we'll talk about that. So let me just quickly talk about some of the first couple of things in my summary there before handing over to Daniel. And I want to talk first about notices, which in the GDPR is called the transparency provisions. And we'll all be familiar that in a notice that you might see on a web page or on a consent form before a trial or in your business and employee manual, used to very kind of bland notices which say essentially, we're not going to be evil, we'll look after your data properly, any problems, give us a call. That sort of bland, easygoing notice is no longer going to be acceptable. There's a requirement to go through and explain to individuals in possibly agonizing detail exactly what data you're going to collect, what you're going to do with it, who you're going to transfer it to. You have to explain if you use automated processing, and then you have to go and give this long laundry list of all the various rights that people have, the right to be forgotten, data subject access, and explain all those in your notices. So if I say this, that if you are perhaps a little bit late to your GDPR compliance and you're wondering what you should be doing between now and May 25, then the obvious advice is to focus on the areas where non-compliance would be visible. And not having your notices in good shape will be an immediate red flag to a regulator or a concerned individual or someone wishing to sue you that you are not in compliance with the GDPR. So notice is really important, and there's some new guidance I've provided a link to there, which I'd commend you read. Consents have changed. Daniel will talk about consents a little bit later. Really important, of course, for health information. The actual precise mechanism for consent has changed in the law, and you need to keep an eye on that. So it's really important to understand where in your business you are seeking consents, and frankly, if possible, you should try and rely upon them much less. We'll deal with that later on. One of the things that's often not mentioned, and I want to mention here, is that in the small print of the GDPR, there's a reversal of the burden of proof. You are in the wrong. You have lost the lawsuit unless you can prove you processed the data correctly. It's a general theme in the GDPR and also expressly relates to the use of consent. And therefore, it's really important, I think, that in the managing of data and the collecting of data that you do, you have a really good audit trail over the notice that's applicable to that processing and the consent, so that if you're challenged, you have a good record to rebut that challenge and try and level up that unlevel playing field, which is a reversal of the burden of consent. I mentioned a moment ago that at the bottom of your notices, we'll have this laundry list of data subject rights. So I haven't got time to go through all of them. Some of them you'll be familiar with because they exist under the law today, such as the right of access. There's often a small payment is required before allowing people to access that data, that payment requirement will go away. So there's a real likelihood that the volume of these requests will increase. And there's also a real likelihood, in my view, that people will start to use these in slightly malicious way. You know, send you a request for right to be forgotten, and then 2 weeks later, send you a request for data subject access to see what you have forgotten. So I think there'll be some game playing around these. And so it's really important, I think, to have a clear understanding how you're going to respond to these rights. For some of you, that'll just merely be by policy, and for others, it might be embedding that into the technology that you use for dealing with individuals. And on the following slide, I've just got some notes about things to think about. Now, one last theme I wanted to quickly mention that, again, I think doesn't get sufficient attention is accountability. And in the bargain of the GDPR, what we have today, of course, is in many countries, there's a requirement to have filings or notifications with the local data protection regulator. And in some countries like France, the filings are quite detailed. And in others, not only do you have to file a registration, but you have to file a copy of a contract if you want to export data out of Europe. All those filing requirements happily go away. So that's the good news. The balance is you are required to keep your own records of your processing, which must be available for inspection by regulators as they turn up to your door. If you don't have these records, they're going to notice. You're not going to be able to create them in time. And so it's really important that this accountability aspect, this record of your processing, is in place. This is a different exercise from data mapping and data inventories and all that stuff people have been doing at the front of their GDPR exercises. This is a slightly different emphasis. And actually, if you are doing data mapping or data inventories, I would kind of think about pausing that, or if you've not started, just wait and focus on how you're going to achieve accountability. A really important requirement, not least because even if you think it's unlikely that a regulator will come knocking on your door anytime soon, and that will be true for many of you, what we're seeing in the contractual amendments that arise out of the GDPR is that your trading partners with whom you share data may want to see the accountability records that relate to the processing you do for them. So there could be a real driver soon that you're going to need this information, and we can supply you with templates of what this accountability information looks like if you need to know more. And even with accountability, there's a lot more governance type stuff mentioned in the GDPR, appointing data protection officers, appointing representatives if you're not in the EU, privacy by design and privacy by default, and data protection impact assessments, and all this sort of stuff. Some of these, truthfully, you can probably focus on after the deadline. It'll be less visible if you haven't got these in place. But you do need to bear them in mind because they will become part of your business as usual activity when dealing with the GDPR post-May 25. So there we go. That's my introduction. Daniel, I wonder if you could help us with some very specific questions and answers that you've just determined under the GDPR.
Thank you, Ashley. That was great, as always. I'd like to start by discussing the definition of personal data under GDPR. The breadth of the definition really differs from what we're used to for definitions of personal information and health information under HIPAA and other U.S. laws. GDPR defines personal data as any information related to an identified or identifiable natural person who is in the EU, regardless of the individual's EU citizenship status. So, for example, I got a question from a client earlier this week who asked me if her shoe size is personal information under GDPR. And I said the answer is yes if she's at a shoe store in Paris, which she thought sounded wonderful, but would not be the case if she's at a shoe store in Florida where she lives. So it's not always quite intuitive. And then, in terms of, when an individual is identified or identifiable, it depends if the individual can be identified by reference to a particular identifier. So, for example, obviously somebody's name or their home telephone number or location data would be another example. So, for example, if you're evaluating use of a mobile cell phone app, if the app is monitoring the individual cell phone owner's location, that location information would be an identifier. So there's some comparison to the list of 18 identifiers that you see under HIPAA by analogy. And then generally the EU data protection authorities deem data to be de-identified, that is not personal data, if there is no reasonable means through which a person with data access, so the data holder or a potential data holder, could use the data to re-identify the individual data subject. Unlike under the HIPAA privacy rule, there's no specific numerical, risk level or specific standard for when there's reasonable means or not reasonable means. So, for example, for key-coded data, the key-coded data holder must not have access to the re-identification key, and the holder of the key would need to secure that key so that, again, there wouldn't be any reasonable means for the key-coded data holder to re-identify the data. While not specifically required by GDPR, we think it would be prudent to obtain an opinion from a statistician, either a biostatistician or other statistician with expertise on data de-identification risk, to deliver an opinion that the data is not personal data, if there's otherwise no other lawful basis for processing the data. So, for example, for various big health data applications or activities, it would be sensible to obtain a de-identification opinion, like is often done for HIPAA compliance, in order to have confidence that there is not a reasonable means to re-identify individuals in the EU. One other difference between GDPR and U.S. laws is that GDPR does not follow the sectoral approach to privacy that is common in the United States. However, GDPR does impose additional conditions on processing of certain special categories of personal data, what we refer to as sensitive personal data or sensitive data throughout our program today. And there's 3 categories of sensitive personal data that are of particular relevance to the health and life sciences sectors. The first, most obviously, is personal data concerning health. Second is genetic data, and third is biometric data. One thing that's important to remember, again, just by comparison to U.S. privacy law, is that sensitive personal data remains sensitive personal data regardless of the identity of the holder of the information. So it's not like HIPAA, where data can cease to be protected health information if it's held by someone other than a HIPAA-covered entity. And again, different than the U.S. privacy scheme, there's no distinction between protected health information that's regulated by HIPAA and consumer-generated health data that's mainly subject to Federal Trade Commission authorities. So the threshold question for a U.S. company is whether GDPR applies to any of its activities involving personally identifiable information or personal data. And the answer depends on three potential jurisdictional bases. So the first basis is activities in the context of a business or other establishment in the EU. Again, establishment in the EU is key here. However, one caution is that the data protection authorities in the EU countries tend to interpret that phrase in the context of very broadly and in such a way that activities that may seemingly have no or very limited nexus to the EU can be deemed in the context of an EU establishment. So it's always important to consider that question when considering GDPR applicability. The second basis is activities that are related to the offering of goods and services, again, to individuals in the EU. And this basis is implicated even if the services are provided only in healthcare facilities or other locations in the U.S. So some examples are for U.S. academic medical centers, if they have medical tourism programs that attempt to recruit individuals in the EU to be patients at a hospital in the U.S., that would constitute the offering of goods and services to EU personal data subjects. Another example would be if a U.S. provider is serving patients in the EU through telemedicine applications. And then the third basis, last but not least, is activities that are related to the monitoring of individuals in the U.S. So, for example, many sophisticated healthcare providers have patient engagement activities that seek to prevent hospital readmissions or otherwise provide aftercare to patients. And if those patients leave the U.S. and return home to London or Paris or elsewhere in the EU, then those well-intended patient engagement programs could end up triggering GDPR. So it's just careful. You need to be careful and consider the scope of access to patient engagement programs, especially when they're conducted through mobile applications that may send automated interactions. One particular question that we often get is about patient portal access and medical record access. And the good news here is that ad hoc medical record access through a healthcare provider's electronic health record system patient portal would likely not constitute the offering of goods and services or monitoring of patients in the EU. But we would, encourage you to evaluate all the functionality that you have activated in your patient portal, and again, consider whether any of the three jurisdictional bases are implicated. So again, telemedicine or patient engagement activities conducted through the patient portal or other applications could potentially implicate GDPR if patients leave your facility and then return home. All right. Now, assuming that GDPR applies, so we have personal data about EU data subjects, and we've triggered one of the three jurisdictional bases, then GDPR requires either consent for the collection or other processing of personal data or another lawful basis for processing. And it's important to note that GDPR only allows a limited exception to the consent requirement or other lawful basis requirement for physicians and certain other healthcare professionals who are physically, who are located in the EU, who are, essentially licensed in the EU. That exception is not available to providers here in the U.S. So then the question becomes, what are the requirements for valid consent? And they're similar to consent requirements or consent principles that we see under U.S. law. So a consent is only valid if it meets four requirements. First, it needs to be freely given, or in U.S. parlance, we often say there can't be coercion of the individual. Two, the consent must include a specific statement of the purposes of the data processing. Third, the consent needs to inform the individual of the nature and extent of the processing. And then fourth, there must be a clear affirmative act that indicates that the individual is agreeing to the processing that's stated in the consent. And there's a variety of ways to do it. So, for example, if it's online, the individual could check an unchecked box. There is text in the GDPR recitals that makes clear that the checkboxes should not be pre-checked in order to meet the clear affirmative act requirement. In addition, there is a fifth requirement to process sensitive personal data, such as health data. The consent must also be explicit for a consent to process sensitive personal data. While explicit is not defined under GDPR, we would expect a handwritten signature or a verifiable electronic signature to be deemed explicit. Again, we talked a little bit earlier about medical record transfers. It's a very common question. Again, typically GDPR would not apply to a U.S. provider's transfer to the EU because they're ad hoc transfers that would not be in connection with an establishment, would not be part of the U.S. provider offering goods or services in the EU, or monitoring of individuals in the EU. Likewise, if a U.S. provider requests medical records from an EU provider, the U.S. provider would not need consent. However, the EU provider would need consent absent emergent circumstances or some other lawful basis. Just in the interest of time, because I want to be able to turn over to Bernadette, I'm going to just skip ahead to the discussion of personal data security, because I guess similar in this case to HIPAA, GDPR has both privacy and security requirements. Generally, GDPR requires both data controllers and processors to implement appropriate technical and organizational measures to ensure a level of security for personal data that is appropriate relative to the risk. So it's similar to the HIPAA reasonable and appropriate safeguards standard. And there's four specific factors that must be considered as part of the risk assessment. The first, which can sound a bit daunting, but is only one of four factors, is the state of the art for security. Two, cost of implementation. Three, nature, scope, and context and purposes of the processing. And four, the likelihood and severity of the risk to the individual's privacy rights. So, your standard two components of risk, likelihood and severity. Good news is that GDPR does not require any particular security standards or code of conduct. Thus, a U.S. healthcare provider, for example, could potentially comply with the GDPR security requirements through safeguards adopted to comply with the HIPAA security rule or to comply with the NIST standard, adopted by the U.S. Department of Commerce. And just the one caution, if a provider wants to rely on its HIPAA safeguards, is that the HIPAA-covered entity should revisit the risk assessment to consider a couple things. One, the HIPAA risk assessment only needs to consider electronic protected health information, but of course a risk assessment for GDPR purposes would need to look at personal data about EU data subjects much more broadly. And then there are some analogous but not exactly the same concepts under GDPR for data minimization, which is like the minimum necessary rule, and pseudo-anonymization, which is essentially comparable to de-identification. So with that, I will turn it over to Bernadette.
Thank you very much. We're going to move out of the clinical care mode into the international research mode. And I want to start by just providing a quick reminder of some of the key building blocks or moving parts here in determining whether you're subject to the GDPR. And I'll go back to the jurisdictional bases that Daniel outlined, that it's the use of personal data of individuals in the EU. And we do have a question from someone about what is meant by in the EU. Is it a resident of the EU? And the answer is not necessarily. It is a person actually physically in the EU, so it could be a United States citizen. And some of the examples that I'm going to review will illustrate that point a little bit further. And it is use of that personal data in the context of activities of a business or other establishment in the EU. It's related to the offering of goods or services to individuals in the EU, even if the services are free of charge and will be provided only in healthcare facilities in the U.S., or involves monitoring the behavior of individuals in the EU. What I did in covering this topic is use examples. So we will move to example number 1. If you want to move the slides for me, that would be great. Thank you. Here we have an academic medical center with facilities located only in the United States. One of the AMC's USC facilities is going to serve as a site for a clinical trial sponsored by an EU-based medical device manufacturer. The trial will involve only individuals located in the U.S., and it might be U.S. citizens or EU citizens, but only those residing in or located in the U.S. will be part of the study. Everybody involved in the study, all of the personnel who are members of the research team, all the personnel who are involved in supporting the study will be in the U.S. and do all of their work only in facilities in the U.S. So this is really the baseline example. It's quite pristine. I set it up that way, but I'm going to make it a little tougher as we go along. Here, the AMC does not need to comply with GDPR because the study will not involve personal data of individuals in the EU, and no entity that is otherwise subject to GDPR is connected in any way with the study. Move to example 2. We're going to start to change some of the variables in the example. So we have the AMC has facilities in both the U.S. and the EU. Only the AMC facility located in the U.S. is serving as a site for a clinical trial sponsored by the EU-based manufacturer. All the other facts are the same here, including without limitation, and in particular, no personal data of individuals in the EU will be involved in the study. But what this example raises, because of the fact that the AMC has facilities in the EU, even though they will not be involved in the study directly, is the question of whether we have triggered one of the jurisdictional grounds, and that is that there is some nexus to some organization that is an establishment in the EU. So here, if we can demonstrate that not only no personal data of individuals in the EU is involved, but also that the AMC's EU facilities are not connected in any way with the study, we would be able to support an argument that we fall outside of the GDPR. Here, what you might be concerned about is whether, because the EU and U.S. facilities are related to one another, all supporting the same mission, you might see an attempt by someone to suggest that the AMC site in the EU is actually helping to solicit individuals for the study, referring them to the AMC back in the U.S., and then we might have the U.S. facility implicated as well as the AMC in the EU. So there we're focusing on that nexus trigger for jurisdiction of the GDPR. And of course, it still needs to involve the use of that personal data, but the more likely it is that the EU-based establishment is involved, the more likely it is that somewhere along the line, EU data of individuals in the EU will be used. Let's go to example 3 and 4. In example 3 here, we have certain study personnel residing in the EU, and they will access and analyze data for the study from their residences in the EU. And here we're raising that same nexus question with regard to the fact that the individuals are in the EU, and the best case we could develop would be to demonstrate that those personnel are not connected with the AMC's EU entity, and therefore not also in a position indirectly to start involving EU individuals in the EU through solicitation or their data or other activities. Example 4 is the same as example 2, but the U.S. site retains an EU-based IT vendor to store and analyze the study data. As Ashley points out to all of us, I've chosen a really tough example here. In some respects, this gets us a little bit into a gray zone, or a gray zone that exists right now. The AMC would again argue it's not subject to GDPR because the study does not involve personal data and it's not connected with the AMC's EU facility. The IT vendor is an establishment in the EU, and so we have a question again about whether there's a nexus now through the establishment in the EU connection. The question would be whether it is regulated as a processor. I would say if it's an IT vendor that is just a business-to-business IT vendor, never gets any personal data of any kind in connection with its business in the EU, you may be pretty clean. However, trying to do the due diligence to determine that as the U.S. AMC would be very difficult, so here we would recommend that you be conservative or consider being conservative and including provisions in your contractual service arrangement that make clear that that IT vendor is responsible for GDPR compliance and will hold you harmless for any violation. Let's go to example 5. Here we are now back to just the U.S. site. Everything is the same, as in it actually should be example 2, but the U.S. site will target individuals in the EU in its recruitment of the study subjects in the same ways Daniel described that a hospital might target patients in other countries for medical tourism. They'll use websites that include study-related recruitment solicitations, and those materials will be in one or more languages of EU countries, and they will post fees that will be paid to subjects in euros. And they will collect personal data needed for subject screening and enrollment. So here now we have personal data involved, personal data of individuals in the EU, and we have triggered the jurisdictional base of offering goods or services to individuals who are in the EU. Going very fast, I know, but the answers are provided for you there. So, example number 6, starting a bit fresh here. All of the AMC's facilities are located in the U.S. One and it is participating in an international industry-sponsored trial that will involve sites in the EU. And it is serving as the lead site, and one of its physicians is serving as the lead PI. Naturally, as the lead site, the U.S. trial site will receive, store, and analyze study data generated by all the sites participating in the study, including the EU sites that have study subjects who are individuals located in the EU. And here, again, that lead site role really gives that lead site the control over the data. So we believe that the GDPR would be a controller subject to the GDPR. Example 7, here I'm moving into the world of secondary research, one of my favorite worlds in the area of research, because secondary research has really become a very, very significant source of biomedical innovation and precision medicine. So here we have that same lead site as in the prior example, but the lead site is based, in the U.S., wants to use personal data from the international trials it participated in to do retrospective data research. So they're now taking the same data and moving beyond the primary study to put it in a repository to do data analysis for precision medicine purposes. And I'm sorry for the bad references to the examples. I'm now dealing with some variations on example 6. So if here we're talking about a consent issue, and I want to raise the specificity of consent requirement. We all have been dealing with that issue in the United States for quite a while under HIPAA and the Common Rule. We have moved closer to a harmonization of those two bodies of law in the U.S. with regard to how specific a consent needs to be to use information you gained from a primary study for secondary research of all kinds, not necessarily currently identifiable or describable. We still have a little bit of influx on that in the Common Rule as we are waiting for its final effective date. If the original study consent did not include specific consent for the proposed secondary research use of the personal data collected in the primary study, a new consent will be needed. And of course, we all know that that is a nightmare. The GDPR doesn't address how granular the consent would have to be concerning the future secondary research, the specificity of the language concerning that used in the original consent. There is some guidance from the Article 29 advisory group that suggests that a general description of the types of areas of research with other safeguards may be sufficient, but there is other guidance out there indicating that you will need a well-described purpose for each stage of the research. Therefore, as in the United States, what we should try to do is think of other strategies, including those that would bring you outside of the scope of GDPR, and a very obvious one would be de-identification. Daniel addressed the de-identification issues. The definitions are very similar. I think we have pretty much identical issues about de-identification and the new world of massive big data and whether certain de-identification methods will be significant. And finally, we do have triggered here, because of the fact that genetic data will be used, the explicit consent requirement, and what that means with regard to other requirements of the consent is unclear. So keep all of those things in mind. I've really tried to give you lots of different elements that help you get more familiar with the different components of the analysis. And the last example throws in the involvement of a CRO here, and we have a US-based manufacturer that's sponsoring an international clinical trial involving EU-based study sites and personal data from individuals in the EU. The study sponsor retains the CRO solely to provide study support, including the recruitment of subjects and data collection, storage, and analytics under the direction of the sponsor's PI. The CRO will not step into the sponsor's shoes as the sponsor of the study for as would be permitted, for example, under the FDA research requirements. And the CRO operates only exclusively in the U.S. The CRO would likely be considered a processor because it will collect and process personal data about individuals in the EU. I think there's a question as to whether it would also be considered a controller, and as you know from the great tutorial Ashley provided, the requirements imposed on each of those two categories are different, so you need to know which one you are. The more comprehensive the study oversight role, the more data analytics, really applying expertise to analyze data and report on what's happening in the study, the more likely it is that the CRO would be considered a controller and possibly a joint controller or co-controller. And if you start to get into a situation where there's more than one controller involved in a study, again, the issue of contracting and appropriate allocation of risk or shifting of risk, protection from risk, indemnification for risk will come up. And I think those types of things will be covered by Ashley if we don't run out of time. Thank you. I will turn it back to you, Ashley.
Wow, that is tremendous. Thank you for that comprehensive work through all those examples. That's tremendous. Now, look, we've got a whole bunch of questions, and I want to make sure that we can get to them before the end. So let's see between the three of us, we can figure these out. And if anyone else wants to send in a question, now is that time. Bernadette, you answered the first one already, I think. Someone's asked, who is in the EU does not mean a resident. You're correct. Any person in the EU is covered by these rules. And moreover, if you are processing data in the EU, it can give rights to people who are not in the EU. So very expansive. Daniel, here's the next one for you. I think if a patient travels to the US for medical treatment, how does the GDPR interplay?
So it'll depend on whether the U.S. healthcare provider is essentially targeting or recruiting individuals in the EU to become patients. So, for example, if someone in a citizen of an EU country is a tourist here in the U.S. or travels here on business and then unfortunately and unexpectedly needs health care from a U.S. healthcare provider, that would not implicate GDPR. On the other hand, if that same individual was, actively recruited to become a patient here in the U.S., say for some type of sophisticated healthcare service, then GDPR would be implicated. Or another potential way that the treatment services could implicate GDPR would be if the individual comes here as just a tourist or business traveler, but then there's follow-up post-discharge monitoring of the patient after the patient returns to Europe.
Very good. So here's a nice easy one next, which I'll deal with. Would access to my company's website from an EU resident in the EU trigger jurisdiction? Answer, no. Happily not. There's some guidance, actually, which we can point you to, which says that if you just have a website to the whole world and don't configure that or target that for Europe, you are not caught by these extraterritorial rules, so that's good news. What's next? If the data is housed in a common EMR, would that trigger GDPR? Daniel or Bernadette, either of you want to answer that?
I'll start, and Daniel may have things to add since we both live in the EMR world daily. I think my first question would be, how is the data structured in the EMR? Is it one big database? Is everything aggregated, or are there different silos or servers that have firewalls? If it's all one big database and you have information on individuals in the EU and individuals elsewhere, then I think you're likely to start to venture into triggering applicability of GDPR. What do you think, Daniel?
Yeah, I think it would just be difficult to have separate security controls for your EU personal data on the one hand and your ordinary HIPAA-protected health information on the other. And I think the good news from the security perspective, it should be possible to have the same controls, security controls for both the HIPAA-protected health information and the EU personal data.
Very good. Here we go. So next question is, if these personnel reside in the EU but access through a VPN, meaning the data stays in the US and the access is virtual, does that matter? Or you could do a similar example where you use a thin client like Citrix to try and keep the data in one country. The answer is no, it doesn't matter. That is still caught by these European laws. Next question is, if the sponsor is EU-based and is collecting data from US sites, do US sites need to comply with the GDPR? So, Bernadette, this sounds like kind of a slight inverse to the one that you've your examples so far.
I think folks are trying to test how nimble we are, right?
Exactly.
Right. So, do you want to take a shot at it, Ashley?
Yeah. So here we go. So I think the logic is this: if the clinical trial is in the context of a European establishment, i.e., the UA-based bit to the sponsor, then the answer is yes, they do need to comply. If not, then they only need to comply to the extent they are monitoring or providing services into the EU. So that's the main rules, how the logic works. And then thirdly, the EU sponsor will require additional language, additional contract language, in addition to the ones you're used to, and that's driven from Article 28 of the GDPR. So that's how that works. I'm hoping we get through these questions. The next one is, can you speak more about the gray area for a data vendor with an EU presence? Would the problem only arise if the vendor was subject to regulation under a separate work that it does, given data has not been processed to individuals in the EU at the time it says provided? Wow, okay, so the gray area. There's a whole presentation in these answers themselves, so let's just do it quickly. The logical components of this is that the application of the GDPR applies to controllers or processors. So even if it's just, and in the history of European data protection law, it's been very badly thought out. And in all the law we've got so far, they just kind of assume that the controller is in Europe and the processor is not. Or the controller is in Europe and there's a second controller that is not. No one's really thought about the reverse, which is this situation where the processor is in Europe and the controller is not, the reverse position. Under the GDPR, it's clear that the processor will be subject to the GDPR. It's not clear if the controller, say in the US, is going to be subject, and so that becomes our gray area. And so it would apply regardless of the circumstance in that question. What is a CRO? Bernadette.
A CRO is a clinical research organization which provides support typically for large studies, very often multi-site studies and international studies where the sponsor is looking for streamlining and through consistency and resources made available by the CRO. So it's a support organization for research. Sometimes under U.S. law, it is permitted to actually step into the shoes of the sponsor, and then it is held to higher regulatory burden.
Okay, I like the next question. What if a US site runs an industry-sponsored mobile app study, offers it solely to US residents, and they have the temerity of going on holiday in the EU, and the app doesn't turn off and still gathers data. Does the GDPR apply? The answer is yes, it still applies to tourists. So the GDPR does apply in that circumstance. Whether there's just an acceptable risk you're going to assume is up to you. But yeah, it still applies even to tourists in the EU with that app that's still running. The next one, to what extent does an EU subsidiary taint the enterprise? Does there have to be a nexus between its operations and the personal data? And so this is a good question. It's all to do with this. Is your business in the context of an establishment in Europe? And I will mention, and I've got no time, but very quickly, we have a famous case in Europe with Google and the right to be forgotten, as some Spanish gentleman wanted his information being forgotten. The case ran, and interestingly enough, it was only Google's sales and marketing department that was in Spain, and indeed across Europe. The main engine for Google sits in the States, and the European court had no difficulty in extending jurisdiction to Google in the US, because it was seen to be in the context of that establishment, its sales and marketing establishment in Europe. So we're worried about this broad interpretation, much broader than you might otherwise imagine. So that nexus could be quite weak, and it still applies. And then I'm afraid the questions might beat us yet. I'm sorry to say, Bernadette and Daniel, but that's our last few. Assuming GDPR compliant consent has been procured for a clinical study enrolling subjects in the EU, what contractual obligations should the study sponsor include in its agreements with service providers that provide data processing activities? Oh, what a brilliant question, and I've got slides to answer that question just coming up in a few minutes' time. It's all around Article 28. And last two, and I can't do any more, I'm sorry. Can you speak about the actual impact to US hospitals, Daniel, this is one for you, I think, who are HIPAA compliant and have robust data governance procedures? Other than modifying our notice of privacy practices and consent form, are there one or two other operational impacts we should immediately tackle? And they've mentioned that I talked about accountability.
Yeah, well, there are a number of other compliance steps that are required under GDPR that there are not exact analogs in HIPAA. So for example, there's a number of accountability requirements, including keeping records of different types of processing, data processing that the organization does. And there's some impact assessments, particularly for big data applications that would need to be documented. So bad news is there are a number of compliance procedures that would need to be taken. What we try to do is develop tools so that it's easier for our clients to document those steps and not have to reinvent the wheel.
Brilliant. And actually, lastly, what if research data of US individuals housed in EU data centers, say Amazon in Ireland, any risk of not being able to access our data if Amazon is subject to GDPR and we aren't? This is the gray area. I don't think there's any risk you won't be able to access your data, so that's good. But you could have an interesting conversation with Amazon to see what they say about that situation and what their interpretation is of this gray area. Now, I'm conscious our hour is up. The secret code, for those that need the secret code for the CLE rather, is star and then numerically 28, star 28. Now, let me just give you an indication of the last little bit of these slides before we finish. I'll take no more than 3 minutes of your time. And the principles of this, commonly, you will sit in a supply chain. And one of the important things to remember is that under the law today, you have this split between controllers and processors. And under the law today, processors are not subject to statutory rules on data protection. So hang on a second. They're mentioned in the Data Protection Directive, but what it says is that if you contract with a processor, you include certain terms in your contract. So if a processor today fails, then they have a breach of contract claim with the controller, but there's no breach of law. That is changing under the GDPR, and it has a very dramatic and important change to all of the agreements supporting these clinical trials we've been talking about over the last hour. And so here we go. Here's a slide that just talks about the requirements in Article 28. I'll leave you to look at that. And here's a slide that gives a distinguishing between joint controllers, which you'll see in the GDPR, and co-controllers, which you won't. And I'm sorry, we can't deal with that. And then here's a little example of this risk that I think arises from the circumstance that processors are now subject directly under the law, under the GDPR. And what it means is, essentially, if you have participants in a clinical trial, and they believe that the trial does not go well, and there's been misprocessing of their personal data, they may choose to sue someone else, such as the sponsor, in the network of contracts providing that clinical trial, much to their advantage. And you will know that in the GDPR, there's now an ability for not-for-profits to bring claims or legal action on behalf of individuals, and it's perfectly possible for law firms to set up these not-for-profits to bring these claims. And so that, together with the reversal of the burden of proof that we talked about before, the ability in litigation to recover your costs from the losing party, means that litigation is a really significant risk, much greater than the oft-mentioned risk of the 4% fines. And so I really would pay some attention to that. And if you want to chat about that more, then we'll also have to talk to you a little bit about Articles 82.4 and 5, which introduce a statutory contribution claim that's often not properly reflected in these GDPR amendment agreements that you often see. So there we go. I wanted to bring that to your attention. There we go. We've run out of time. Thank you very much for bearing with us on this hour-long presentation. The slides are available to you. They contain a whole bunch of other interesting links and steps for you to consider. And Daniel and Bernadette and I thank you for your time, and are happy to answer any questions afterwards that you may have.